Okay, so we can start now. So welcome everyone. Thank you so much for joining. And thank you, Rahul and Andre, for supporting the first DAAC session. Before we start, I'm just going to share about why DAAC. So obviously during my early associate journey, I have lost so much money as well. So there was one moment where I've lost almost $25,000. And I asked my wife, what's going on? How can we get the money back? And even she had some similar situations, and Rahul helped her. And she won the case because of Rahul. Because we cannot change the bad behavior, what's outside, but at least we can have some system which can protect our interest. So that was the main reason we started with the DAAC. Some of the members from the WhatsApp group, they have personally messaged me a lot of questions. Some of the members, they're going through situation like this right now. One of the members is expecting almost $35,000. And so many members, they were asking me, what should I do? Because based on my personal experience, they don't have the mindset to file a legal case against the owner. They would suck up $25,000, but not do the legal action. So that's the main reason. Let's learn the strategy, how we can protect ourselves, how we can have the system so that even though there are bad behaviors outside, we can at least save our interest and at least get the fair compensation. So over to you, Rahul and Andre.
Thank you very much for the kind introduction. And Rahul, I think he'll talk a little bit more about this later, but he's got some friends who are dentists as well. So your situation and your wife's situation are not unique by any means. It's unfortunately common in your industry. So without further ado, we'll jump right in. Okay. So we're Humber Bay Law. We're a small boutique firm located in Toronto in the West End. We have two offices, one in Lakeshore, one in Sherway. We're a full service firm. Rahul and I in particular are experts. I use that in quotations for myself. Rahul's been in legal practice for, I think, about 30 years. So certainly he's an expert. But we specialize in litigation, is the accurate way to put it. And in particular, corporate commercial litigation, right? It's contract disputes and things of that nature are our bread and butter. Today, we're going to talk about some very practical things. We're going to try and keep things away from the theoretical, right? We're going to focus on what kind of problems you can expect to have in your industry in terms of owners not paying you or contract disputes and things of that nature. What you should do when problems do start to crop up. When is it necessary to involve a lawyer? And you think ahead, as Romik said, instead of trying to react after the fact. That's important to be prepared for conflicts and hopefully not arise, but if they do, you'll be ready. Again, the goal is not to create conflicts. Our goal is to reduce conflict by creating predictable ones, right? So today, by the end of this, we should be able to know how to identify some red flags in contracts, how to preserve important evidence or documents that are going to help you in a legal claim. God forbid you should become involved in one. What kind of disclosures or what kind of relationship green flags you should look for, what kind of contract clauses are good for you and which are bad, and so on and so forth. And at the end of it, you should also be able to have a snapshot of the legal journey of a particular claim, whether it's going to be through small claims or superior court ultimately, or arbitration. That's more rare. The majority of the time, associates in legal practice or in dental practice will be considered independent contractors. Okay, but just because you call somebody an independent contractor doesn't mean they are one, right? This is a very common issue, and it's one of the things we'll touch on briefly. So the first thing to keep in mind is that there is a distinction between written and unwritten contracts. Okay. A good contract is not necessarily a contract that is particularly one-sided, right? So you could have a very harsh contract that gives the owner a lot of power, but it's very clear. Really bad contracts are contracts that have a lot of ambiguity, right? Vague language gives the party controlling the relationship, in most cases, the owners, the ones in control of the staff, the reports, the payment records, and so on, room to interpret the contract and the relationship in a way that benefits them later in case a conflict does pop up. Okay. A good agreement is good for both sides, right? Because the associate gets a predictable pay and a clean exit if they want to leave the practice. And the owner gets the benefits of having them work there, the confidentiality, quality standards, the expectation that they're going to be working the days they're scheduled to work, and a fair way to protect the legitimate patient goodwill that they accumulate during that time. I get asked sometimes the question of which clauses are non-negotiables for associates and the kind of things you should look for in a contract. At the very minimum, I would say the most important thing is the sort of compensation formula. Okay. So how is your compensation calculated? Being able to understand that particular formula and how, what goes into it, and getting the reports and the audit rights that you need to actually trace that information, right? So the records and the insurance records, the payment records, and so on. Okay.
We'd like to talk about compensation clauses, perhaps the most singularly fundamental clause in the contract. And most of the dental associate contracts that we come across, and we have written them, I don't know if we had mentioned that our firm represents both dental owners and dental associates. So we are frequently on either side of a dispute, contractual dispute, or on either side of a litigation proceeding. It's the most fundamental clause in your contract. And what we see commonly is a range of 35 to 45% of collected production revenue being paid to the associate dentist. The range is based upon, of course, many factors, which I'm sure you are familiar with, including the location of the practice, the volume, the number of charts in the practice, and sometimes in remote locations, associates can negotiate or attract a higher percentage of the billing revenue. So those are the factors that we have come across in our experience in drafting, negotiating, and interpreting associate contracts. Now, for example, 40% is not a compensation clause. 40% is only a number. The issue for the associate is 40% of what? And 40% payable when, and 40% based upon whose records. So one as an associate, you can interpret that it would be ideal for you to have 40% of billed production. We don't see that in our associate contracts generally. What is paid to associates is frequently 40% of collected production. There's no question that it's the owner of the practice or the practice management which has the best access to the data. We recommend that associates maintain close relationship with the front desk staff or the dental office manager and either request as a contractual right access to billing records and collection records, or to establish and maintain relationship with those members of the practice who control that information so that you have access to such data. We're familiar with the deductions. The deductions are the largest deductions in a dental practice, of course, are the dental lab fees. Production should be defined. And within the definition of production, one can consider funds collected, reversals, write-offs of patient accounts, discounts, and of course the lab fees. The term net collections must be defined in an associate contract. And you can interpret and understand how net collections can be calculated in your favor as an associate, as opposed to how that might be calculated in the owner's favor. When negotiating such a contract, there can be an imbalance or unequal bargaining power. And quite honestly, I've seen that unequal bargaining power pendulum swing in either direction. Generally speaking, the imbalance is in favor of the practice owner. But there are circumstances where the imbalance can also be in the associate's favor. Understand your bargaining position and manage that in your best interest when entering into an associate contract.
Okay. So very quickly, we're just going to touch on this concept of employee versus independent contractor. Generally speaking, like I said before, most associate contracts establish a relationship of independent contractor. Okay, which means that for all intents and purposes, you are a separate business providing a service to the clinic. And as a result, you are not an employee at the clinic, right? You're a standalone sort of company. Where that line gets blurry and where you should consider whether or not you're an employee-employee relationship is when the owner starts controlling how your business functions, right? In essence, the owner gets to set all the fees, gets to set your hours, gets to set your scheduling, right? And it prevents you from working elsewhere, right? Exclusivity and so on. Where there's no meaningful business risk to you in terms of your materials or your ability to operate and put hours in. And when you don't have access to the information that you require when you do your billings and so on. So no ability to verify collections means you're in a lot of situations, essentially puts you in the place of an employee, which is a whole other different basket of worms, if you will, because ultimately that relationship will be managed by the statute of the Employee Standards Act, right? So you get things like vacation and benefits and mandatory pay if they terminate you and so on and so forth. So just keep an eye on that. It does happen, but it's not particularly common. One thing to keep in mind for your contracts is there's a category of contract clauses or terms called restrictive covenants. We're not going to go into too much detail about them because they could be all kinds. There's a very large variety of them. But the key function here is that if the contract contains things like a non-compete clause or a confidentiality clause or a non-solicitation clause for patients, those are called restrictive covenants. Okay. They do different things, but they restrict behavior, right? Which is why they're called restrictive. When it comes to restrictive covenants, a lot of them are not going to be legally enforceable. And a lot of them are going to require going through them with a sort of fine-tooth comb to determine whether or not they are enforceable. So we see a lot of the times non-compete or non-solicitation clauses that are too broad. Okay. So when you leave a dental practice, you're not supposed to solicit all the patients to come with you. But in accordance with your own rules of professional conduct, you have to notify your patients, right? That you're leaving this practice, you're going to another practice, so that they have continuity of care with the care provider they're choosing. Your owner or the owner of the practice is not allowed to keep those patients if they want to go with you, right? Nobody owns the patient. And they're not allowed to sue you for telling the patient that they're leaving, right? That you're leaving. This was the big issue that Rahul touched on a few moments ago, right? Is this question of undefined collections and lack of financial transparency. This is the most common loophole, honestly, that you'll see in this kind of a relationship, because it allows the owner to subtract items that the associate never agreed to subtract, potentially, when they were negotiating the agreement, like lab fees and refunds and insurance reversals, discounts the owner gives their uncle or cousin for services. and so on and so forth. They could even tack on merchant fees or admin fees and so on for the clinic. And if you didn't agree to that, if you agreed to, when you heard 40% is the example, right? And 40% to you was 40% net, i.e. 40% of whatever I bill, then when that 40% gets attacked by all these fees and whatever else the owner tacks on, that's gonna leave a bad taste in your mouth. So it's very important to look at what net collections actually is defined as in the contract. And if you don't have a contract, it's even more important to talk about and have in writing how that's going to be defined. If a dispute happens to crop up either at the beginning or the middle or the end of the working relationship, you should always ask for the reports for payments in writing. Okay, that'll allow you to track all of the sort of alleged fees and alleged costs that they're trying to tack on to reduce what's actually payable to you. Okay, so a good contract is going to have, it's going to address what happens post departure with the collections. Say, for example, if insurance pays after an associate leaves, that final reconciliation should capture those funds within a specifically defined period, right? You shouldn't be out of money for work you already did just because you're no longer there, right? Insurance takes 2 weeks to pay and you left a week ago. Just because you've been gone for a week doesn't mean you didn't do the work, right? That money should still come back to you. And we see a lot of the times owners try to keep that money and then try to retroactively justify why they're keeping that money by saying, oh, you did bad work, or there was a bad review on the website, or you owe me for this, or you owe me for that. So it's very important. If you ever think you're being underpaid, again, ask for those weekly, daily, or monthly production reports, monthly collection reports, insurance adjustments or write-offs and lab invoices. Basically ask for whatever invoices that the owner is alleging the fees are being withdrawn from. Okay. We've got a section on lab fees.
And of course, I think our audience would be well familiar with what the lab fees constitute. It's a major variable cost in the operation of a dental practice. On that issue of the contract coming to an end, we frequently see that a typical claim by an associate, a legal claim, is in respect of their last month's collection, their last month's pay. So in some dental contracts, there's provision for a holdback, and we have seen that frequently. And the holdback should be resolved between the associate and the owner within a fixed period of time. So the contract provision may provide for the owner to hold back some amount, but that holdback should be for a time-limited purpose, whether it's 30 days or 60 days. There should be provision for accounting and resolution of the holdback. On the slide, we're addressing some administrative responsibilities that are often included within associate contracts, that as senior members of the management team or of the production team, the associates are often required to participate in some administrative functions.
So a lot of the times we hear about associates jumping out of school or eager to find a job. And lo and behold, you find a place in a clinic. You're very excited to get started because you want to make money to pay for that not insignificant school debt. And a lot of the times you're working without a written contract. And with some clinics, you might not ever get a written contract, unfortunately. So what happens if you don't have a written contract? What happens if your contract is unsigned or oral or implied based on how you do business, right? So just because something's not written down doesn't mean there's no contract, right? As everybody knows, I'm guessing from watching Suits or Velvet or one of the other million lawyer shows, you can have oral contracts. It happens all the time. When you don't have a written contract, it just means that the evidence is that much more important, okay? The key evidence for establishing the terms of an oral contract or an implied contract are basically what was promised, right? What work was performed, what was billed for, and what was paid, right? The repeated conduct of the associate and the ownership or the office in general is what's going to establish those terms. Because a judge, if there's a disagreement, is going to look at, okay, he says the contract was this way, and he says the contract was that way. And the way they're going to square that difference is they're going to look at the evidence, right? They're going to look at the documents, they're going to look at the billables, they're going to look at the correspondence between the parties, and they're going to try and bridge that gap by saying, okay, I can surmise that the contract terms were A, B, C because this is what they did, right? They did A, B, C. They billed this way. They talked about things this way. This is how they work. And they did it repeatedly, right? Which shows that there was an implied agreement that was never explicitly stated that, look, this is how things are going to work. Okay. So whenever possible, get instructions in writing, ask for things in writing, ask for things like invoices, pay statements, production reports, day sheets, any messages confirming percentages or payment timings, right? Because that stuff is what's ultimately going to be used to decide your conflict. Okay. An implied or oral agreement cuts both ways, right? It can hurt both sides because it's the ultimate vague contract, right? There's nothing in writing. So it means that all of the weight for establishing what actually should happen goes onto the evidence to prove deductions, to prove holdbacks, forfeiture provisions, restrictive stuff, post-departure limitations, stuff like that. God forbid an owner try to say, look, we had a promise for no solicitation or non-competition when they don't have a written provision for it. The judge is going to have a hard time accepting that. So it's not just associates that get hurt by stuff like that. Right? A lot of people ask, look, I started working before I signed anything. What should I start documenting from day one? Again, you want to confirm those percentages, your comp base, your compensation base, your pay dates. What our common deductions look like? What are the lab fee terms, termination expectations by email? Get those in writing, very important. And send whenever you get a kicking of the can down the road by ownership, when you say, look, hey, where's my contract, so on. And they say, oh, we'll sign it later. It'll come next week, or my lawyer's busy. And so sometimes they are. Just send a polite summary of the agreed terms that as you understand them immediately by email or in writing, by text, however you can. Because what that's going to do is it's going to put the ball back in their court, right? You're telling them those are the perceived terms, right? Until you tell me otherwise, right? So if they don't tell you otherwise, those are the perceived terms you're working by. And if they breach those terms, then look, hey, they've breached the agreement, right? For written agreements, what do we care about before signing? We talked a little bit about important terms and sort of restrictive terms and terms you don't want in there. When do you get a lawyer to look over the agreement? The fact of the matter is most lawyers, our office included, will do fixed fee or limited scope reviews for clients. Okay. Typically these agreements aren't super complicated. In terms of the range of kinds of agreements, they are generally tend to be pretty standardized across the board. Again, a lot of them are using those terms which are not enforceable. And so you should always pay a lawyer to review your contract, okay? But if you're not going to pay a lawyer, then you should at the very least have those things in the back of your head, right? So think about, okay, what is the owner allowed to deduct from my pay, okay, in the contract? What is included in net collections? What does that term mean, net collections, when the owner uses it in the contract? Are there any clauses that let the owner change compensation, right? Or change my schedule for work without notice to me? These are all things that could affect your livelihood, and they're very important to look through in a contract if you can do it yourself. A lot of the times, we recommend that you seek a trial or onboarding clause for 30 or 60 days. Basically, it's a walk away provision, right? Hey, look, we're going to test out the working relationship for 30 to 60 days. And we each reserve a mutual right to end that relationship with no strings attached on short notice during that trial period. And that allows you to test how they do business, test if they're trustworthy, and so on, without the worry of being locked into a long-term contract, which if you break before the term is up, then you might be on the hook to pay the owner for lost wages. And so on.
Another benefit of having a short trial period or a period where the agreement can be terminated is that it'll allow you to complete 1 or 2 billing cycles. And when you do that, you will have firsthand experience as to how the formula works, and so that there's no ambiguity or uncertainty to which you're committed on a long term. So there are scenarios where payments are withheld, and this slide addresses or lays out a strategy or a plan, an action plan for the associate to follow where there is a withheld payment. Of course, and you'll at all times maintain records of your production. That's step number 1. We recommend that you stay on top of the numbers and that you participate in the accounting process. Step number 2, send a focused accounting request within your team, within your management team, within your practice. Step number 3 is important. Preserve your evidence. As an associate, you as well should maintain records. And sometimes associates don't do this. However, we highly recommend that for each and every billing month, you also maintain records of your production, records of the amounts collected and received, and of course, records of what you drew or what you were paid by the office, and some kind of ongoing record of any disagreed amount or disputed amount, which we advise that you raise with your practice owner promptly. In cases where we have acted on litigation matters between the associate dentist and the office and the owner dentist, often we find that we're calculating arrears of payments that span many years. And it strikes me as unusual that one might let some disagreement or dispute about a payment go unresolved for a long period of time. Our advice is that you not do that. Again, it's an issue of the power imbalance, or perhaps the humility or the politeness of the associate. There's no need to be that way. It's a mutually lucrative business, and I'm sure that all of you understand that. And there's no reason why any disagreement over an uncollected amount should be delayed or deferred. Raise it politely, raise it with a goal of reaching understanding, and try to avoid step number 4. Step number 4 involves typically a lawyer, and we don't want you to end up there. And similarly, we advise our practice owners, don't let it get to this point, because the associate dentist is like a goose laying a golden egg every month. And we advise our practice owners to treat the associates very well. However, resolving a disagreement takes 2 people who are interested and willing and eager to talk to each other. It requires making time, finding time, and raising the issue. If you end up in step number 5, we were asked to address this issue by ROMIC, and here is a hierarchy of what your options are. The Ontario Small Claims Court allows you to raise a claim of up to $50,000. In the duration of my practice, the Small Claims Court limit has gone from $15,000 to $25,000, and now it's $50,000. $50,000 ought to cover most of the claims that an associate has against a practice owner. So your litigation claim can and often will be handled in small claims court, but we don't want you to get there. If your claim exceeds the jurisdiction or the limit of the small claims court, it then goes to what we call the Superior Court of Justice, where there is no jurisdictional limit. If you are an employee, then you may raise an Employment Standards Act claim.
Again, employee relationships are rare in your situations, just because typically, and so it's the way it works for lawyers as well, right? A lot of lawyers hire independent contractor lawyers to work for them. And you either engage in a partnership with other lawyers, right? In your case, other dentists, or you open your own office eventually, right? When you've established that patient base and you're able to do that. And then you hire your own associates on that basis. A lot of the questions I get that go back to that continuum that we were just talking about is, when is it worth the money to hire a lawyer? When does it actually make sense in this timeline to hire a lawyer? Raul highlighted it's at step 4. Okay. But I don't disagree. You definitely need a lawyer to write a demand letter. I would start thinking about, or at least consulting with a lawyer, even a little bit earlier. Okay. Around step 3, because usually around step 3, you're able to tell if the owner is going to, if they're going to be cooperative, let's say, in handling the dispute. And he highlighted something very important that we also spoke about with some of our dentist friends and longtime clients. A lot of these disputes stretch on for months and years. And because everybody's so busy, the owner, a lot of the times, is another dentist, and the associate obviously is very busy, the dispute gets put on the back burner. And then the associate sort of resents the owner for that. And because there's very little communication, eventually it comes to a boiling point and nobody wants to be reasonable. The associate says, I want my money. The owner says, I don't owe you money. You didn't bring it up before, and so on and so forth. So we always recommend candid communication going both ways. Hey, look, notice I was short a little bit this month, or I was short that month. Tell me why. Let's talk about it.
I might just add there that there's a 2-year limitation period. What that means in law is that if you were to sue today, you're not able to sue for an amount that was owing more than 24 months ago. And on that basis, sometimes you're forced to forego a claim. So by all means, if there is an outstanding claim, keep in mind that after the 24th month, you are not entitled to raise that claim against your practice.
Very important. Here, we're going to very briefly talk about some cases, fairly recent cases between disputes between owners and associates. And they illustrate some of the points we're making here today, right? So this first case, Lyons and Multari, is an appeals case. So that means it went from the Superior Court to the Court of Appeal, and it's relating to a non-competition restrictive covenant, right? So it's a clause in the contract that says, look, you can't compete with me, between an oral surgeon associate and their clinic. The sort of takeaway from this case, it's very important, is that just because the contract says you can't compete with the clinic, it doesn't mean that clause is actually legally enforceable, right? These clauses, because they're so powerful, they give the owner so much power, are very scrutinized by the courts. They have very strict requirements to be enforced. Okay. So don't be scared when you see clauses like this, because a lot of the times they're too broad and they fail. Okay. That's the first thing. Coscarello Dentistry versus Harvey. This is a very recent appeals case as well. This has to do with oral agreement issues. Okay. And it has to do with patient mobility between associates and the existing clinic. Okay. So patient mobility is a tricky issue because on the owner's side, obviously, they want to keep as many patients as possible going to that clinic. On the associate side, if you want to leave to go open your own clinic or go work somewhere else, you want to take your patients with you, understandably. From a conduct and ethics point of view, your medical ethics and your conduct has to be unimpeachable, right? As does ours, right? It's very scrutinized. Continuity of care of the patient is the number one priority, okay, in these cases. So it doesn't matter what the owner wants and how much they complain and whine about, oh, you're taking my patients and so on. The patients have a right to know where their care provider is going, when they're leaving, and how their continuity of care is going to be handled. That's the number one priority. Okay, so again, Coscarello talked about that and says that patients aren't property. They can move of their own free will. The owners, they don't have a monopoly on their patients. The final case is this case of Paula Viana and Kapoor. Again, this one is in Ontario's Superior Court case. It was not appealed. So that means that Paula Viana won the plaintiff always appears first in the order when you see a case title. So in this case, the Dentistry Professional Corporation won. The case in this particular matter was about contract interpretation. Okay. And because the owner is the one responsible for offering the contract, there's a doctrine or a concept in law. Okay. It's a very fancy Latin term called contra preferentum. Okay. And all it means is that the person who drafts the contract and presents it, okay, if there's something later in that contract that happens to benefit the other side, the person who drafted it can't say it was unfair, right? Because it's their contract. They drafted it. So this was that case, right? There was terms in that contract that allowed the associate to do certain things that the ownership thought they shouldn't be able to do. And the court said, hey, look, they're allowed. It's your contract. You screwed up by drafting it. So sometimes you'll see cases where you want to keep certain terms in a contract because either they're going to be in your favor or they're going to be against the owner and more favorable for you long term.
The case law does lay out principles, but what we've seen over the years is that the resolution of these issues are typically very fact driven. So whereas competition provisions as a rule in Ontario are not enforceable, they will be enforced where the radius of non-competition is reasonable. That varies, and that varies whether you're in downtown Toronto or whether you are in rural Northern Ontario. Applications of the rules also varies based upon the conduct of the parties. So if the associate, there's no evidence of an associate poaching charts or patients, but they've fallen somehow within the radius because the radius was too broad, too large. In those cases, the contractual non-compete may be struck down or unenforceable. One of the reasons why consulting a lawyer is a great idea, and we're here and available, even if you're seeking an opinion and you don't actually have a dispute, feel free to reach out, email us, and at all times confidentiality is assured. And if there's something that you're uncertain about, just feel free to write and ask or call.
The important takeaway, apart from dealing with the conflicts in a concrete manner, either through demand letter or small claims court or God forbid superior court, is that as an associate, you're a service provider. Okay, you're a standalone corporation. You are a professional, ultimately. As a professional, you can't just rely on an owner to hold your hand or do things that are always in your best interest. You have to take care of yourself a lot of the times. That's how corporation negotiations and dealings work in Ontario and in the whole capitalist world. So in light of that, we always recommend that as associates, you wear that business hat, not just the dentist hat, and you do things like keep copies of all the important documents, contracts, amendments, confirm verbal discussions in writing, right? You just had a very important conversation with the owner about X, Y, or Z. Send a follow-up email. Hey, I wanted to confirm this is what we talked about today. Save your emails and texts. Keep and review your pay statements and invoices. Don't be too focused on just the service part of it, because unfortunately, you are a corporation, you are a service provider. So you got to worry about the business side as well. Okay. And it's in the best interest of everybody because it keeps the expectations on an even level and it allows both sides to have a predictable working relationship, which is ultimately what everybody wants. Right? It's what's most lucrative for both sides. And I think with that that's really the end of our presentation. And we're going to just open it up to questions for the next 20 minutes or so, if that's okay with you, Rowan.
No, for sure. Yeah. Based on this session, almost like 75% of the questions is already answered. Because
Okay,
a lot of people they have messaged me personally, and I think this presentation is answered to those questions. But again, if you have any other questions, we have 21 members. So if anyone has any questions, just turn on your video, or maybe you can just raise your hand and then let's ask the question.
Yeah, I think if you write them in the chat as well, we'll be able to see them.
While we're waiting for a question, here's another topic that I'll touch on briefly. we had recommended that you keep a good relationship with the bookkeeper or the accountant or the practice manager, and that you stay at a friendly level, very familiar and in tune with the collections. Here's another aspect of associate management of an associate's practice. Keep track of the annual insurance limit of your patients. And I hope that, I'm sure that you're all familiar with that concept. For example, if the patient has up to $2,000 of annual insurance coverage, even if you don't have good tracking of how much has been charged year to date, you should be able to look at the patient's chart and in your own mind, make an assessment as to whether you should check. And the reason for that is that if you have a patient who is approaching their annual insurance limit, and you then get informed consent and carry out very significant procedures for that client, you're putting your own collection at risk. So that's just another little tip for an associate. I think there's benefit and advantage in monitoring your patients and looking at their insurance charges year to date and how much they have remaining in this period.
It's a very good business practice that takes the power away from the owner in terms of that informational asymmetry, because it lets you know ahead of time if a patient's bill is going to be covered right away by insurance, or if you're going to be waiting a while for payment out of pocket.
I have one question. So there was one member, she asked me about this situation I have never experienced. So the owner asked her to sign a contract for 1 year term. She cannot leave. And there is no onboarding period. And if she leaves, let's say after 1 month, owner will not pay anything.
So that's very strange. So then she's being paid presumably month to month or bi-weekly, right?
It was her first month. Now she was like, I tried for a month, I didn't like it, so I want to just end it. So now, based on the contract, it says if you leave, then that's it, you will not get paid.
For the month she worked.
Yeah, exactly. I mean,
yeah, that's usually illegal.
She has a claim. She has a claim in once again in Latin. The claim is called quantum meruit, and it means that you're entitled to be paid for the value of the work you have completed. And that quantum meruit legal concept or legal doctrine can prevail over a written contract term, which is the opposite. The obvious argument is that contract term is unfair. And a good lawyer will have that contract term overturned and get to the associate their money.
That's good to know. So we have some question here. Can you see, Andre?
Yes, I see from Maria the question. How do you view when hygiene chairs are not in your production report, but technically charged on your claim? Do we need to keep track of this or not? Not aware exactly how many x-rays keep getting billed. So by this, I presume maybe Maria, you want to chime in to clarify. I misunderstood your question, but I think you're asking if in this case, it's equivalent to a lab fee, right? Like a disbursement or like a third party fee that you're paying the office, and that's being deducted from your fees for x-rays or for the use of these chairs. You should absolutely get, x-rays are billed under my ID, but not paid to. Oh, that's something that you should look into for sure, because if the office is billing using your ID and they're not remunerating you for it, then not only does it possibly open you up to some liability if the x-rays aren't done properly here, right? Or they don't show something, or they do show something rather, and doesn't come to your attention, right? And God forbid something happens down the road. That's your medical liability on the line, right? If it's being ID'd under you when it gets pulled to OHIP.
What I've seen in our practice is that the associate is to be compensated for their review of the x-ray. And in fact, even where the hygienist completes an x-ray, and that is your patient or under your care, the x-ray that's completed by the hygienist can generate a billable service for the associate dentist. So I don't know if that's what your question is specifically addressing.
Yeah, I can add it here. So I did read about this situation. So Maria, the only thing is you're taking the liability, but you're not getting paid for it. That's it. So if you're okay with it, then that's it. Because when you discuss this with the RCDSO, I have tried to email the RCDSO, and the answer which I got it, this is a business relationship between the you and the another dentist. You guys figure it out. We're gonna come in between. We're gonna come in between if there is a patient involved. So anything where patient is not involved, it's all business relationship, and that's it's. If you're okay with it, that's it. Then you are liable for it.
That's very true. We've had situations where the RCDO, where an owner threatens to complain to the RCDO for something an associate did, like asking for reports or billables or lab invoices proving deductions. And you shouldn't be afraid of those threats, right? Because the RCDO is there to protect ultimately the patient, right? The public at large. They don't care about, forgive the phrase, your petty business disputes between dentists and owners. And the same goes for our regulating authority, the Law Society. The Law Society doesn't care if lawyers have a disagreement between themselves, as long as there's no patient or client that's being negatively impacted. And if that happens, and it sounds like maybe it could, then it's important to get the RCDO involved.
We certainly hope that practice owners are not using the regulator, Royal College of Dental Surgeons of Ontario, as some form of threat with their associates. I have heard of that happening, and in fact, we've seen that happen. And if there is any discussion of that, that's a very good indicator that you have a bad relationship between the associate dentist and between the practice owner. We've acted for dentists when faced with an RCDSO investigation, and we fully understand that associates are more vulnerable and perhaps more fearful of an RCDSO complaint or an investigation. Seek representation. If you face a professional complaint and it's a threat to your license, you should not hesitate to retain a representative. It allows there to be a filter and for there to be an in-between party in the communications between the regulator and the dentist. A tremendous advantage in an investigation. In our experience, the RCDSO is focusing on a few areas of practice. Number one, that you are not infringing the rules of personal relationship or amorous or sexual relationship with your patient. Number two, the RCDSO is very focused on insurance fraud. And we can address that further if you wish, but insurance fraud, I think, is well understood by all dentists.
Overbilling and over-reporting for services. It's pretty common in the industry, unfortunately.
Issues pertaining to the co-payment. And then thirdly, carrying out a procedure without informed consent and without the chart being annotated in respect of informed consent. These are the main areas. And we should not, as I would suggest respectfully, that associate dentists should not be too concerned about the regulator's involvement or threat of the regulator's involvement if you're not on the wrong side of any of those three topics.
We've got another question here from Harpreet. She's asking, if we left the clinic already, can we still request the end day report for the days worked? For some software issues in the clinic, I didn't get the end day report. Can the clinic refuse to provide it? So same as ultimately, it's going to depend on the contract. If you do have a written contract, they shouldn't refuse to provide it because, again, it's your records, right? You're entitled to them to do your own accounting. And no, they shouldn't withhold them. And if they do withhold them, then it presents a problem, right? Because for whatever reason, they're refusing to cooperate, which is very strict, with a very straightforward request. And typically what people do that is that they're trying to be unreasonable or they're trying to hide something. And then she asked a follow-up question. In the same clinic, they mentioned you would get 40% of collections, but when I gave notice that you were leaving, they gave you checks for 100% of all collections to deposit in your account and then asked you to send 60% to them back. Is this going to cause you any issues in the future? It's hard to tell. It's very I wouldn't say unreasonable, but it's weird that they've done it that way. It's a little strange. Typically, obviously the clinic collects everything, deducts the overhead for staff and materials and whatever the contract says it should be deducted. And then you get your 40 out of that. It sounds like they're doing the opposite here. They're saying, look, collect 100% of everything that insurance paid for, and then we'll bill you 60% of that back, which is just very strange to me. I would ask for an invoice for the 60% or ask where that 60% number comes from if it's not in your contract.
It feels like there's some accounting manipulation perhaps at play. And perhaps you could bring that to our attention and we could guide you on that, Harpreet.
Maybe I can add here. So basically, if the check comes to the name of the provider, and if the office deposits it, and you can literally call the insurance company and they say, you know what, I didn't get the check. So basically, the check, the payment will get reversed again in the future. So to prevent that, the office may give you just check to deposit in your bank account and give us the 60%. So it's like safety net. And I've seen this. I know a few times I've seen.
So it's an insurance snafu.
Yeah,
because but the dentist's name is
because dentist can call the insurance and then say, you know what, I haven't received any payment. And this is one reason. Second reason is if the office hasn't signed any authorization document from the provider, then they can do this.
Right. Yeah, that's why it's important to do those kinds of things and communicate with the clinic, right? Because you want to make sure that the process needs to be smooth. Everybody is in this industry is very busy. You can't be chasing down checks that went to people that weren't supposed to. And there should be a standardized process, and you should communicate with the clinic to make sure that insurance checks are being written to the right people to enable that process. Nida asks, can the location clause be enforced wherein you cannot practice for 3 years in another office within a 5-kilometer radius? Now, this is like a classic hypothetical. It's probably real, and she's probably reading that off her contract, but it's the sort of question you would see on a legal exam. Not to be a lawyer about it, but the answer is it depends, right? It could be enforceable. It could be completely unenforceable. So for example, 3 years is a fairly long time. That's on the high end in terms of length of time. And 5 kilometers could be a reasonable radius if you're in Whitby, Ontario, or if you're in somewhere up north, but it's not reasonable if you're in downtown Toronto, for example, right? Where there could be a dental clinic every 3 or 4 kilometers.
Or every 300 or 400 yards.
Yeah, or every 300 or 400 meters, exactly. So it's going to depend on your area, your geographical area, and it's going to depend on other factors like the length of time. 3 years it's a little long, quite frankly. I would push back against that if possible. Usually you see a year or 2 years, especially if the geographical location sort of radius is reasonable, then that length of time term should also be roped in to also become reasonable. Yeah, there are multiple dentists in a 5-kilometer radius. Exactly. So what they're trying to do is they're trying to prevent you from going to work with another office within 5 kilometers. But if you live in downtown Toronto, you can throw a rock and break a dental clinic window.
One has to look at it from all angles. A court might also consider if you were to be 5.1 kilometers away, are there employment opportunities or are there business opportunities? And if the answer is yes, then perhaps it would be enforced. At the same time, if you're in a small town, which is only 3 kilometers across, then the 5-kilometer radius requirement eliminates you from being anywhere in town. So that would be unenforceable. Again, these questions are often determined based on specific facts of the situation. If it's in Peel region and they're asking you to go 5 kilometers away, my opinion, and there's no guarantee, is that it's probably enforceable. It's probably a valid clause.
Yeah. At least for the geographical area component, for sure. It could be.
See us for more details or write to Andre or myself directly, and we'll be very happy to give you a formal opinion.
Ceel, Seal, I want to say. I don't want to screw up your name, because that isn't your name. Can a practice enforce a fee if you leave and a staff member follows you? I've seen it in contracts that an associate can be held accountable to pay up to $250,000 if another team member leaves after them. That is very interesting. So this kind of goes to the non-solicitation, right, area of those restrictive clauses. Non-solicitation can also refer to other associates at the clinic or other staff members as well as patients, right? Your name is Eliza. Okay. Yours. You can't just put a fine into a contract without any legal logic behind it, right? So if they're saying, oh, we're going to charge you 250 grand, that 250 grand number has to be based in reality. Okay. So first off, in order for that clause to be enforceable, the solicitation, it has to be written in a way that's reasonable, first off, right? So you would have had to solicit that person to leave with you and say, look, it sucks here. Come with me. We're going to make $1 million down the street at the competitor's office. If that didn't happen, then they don't really have a case. Just because you leave and a month later somebody else decides to also quit and go work with you, it doesn't necessarily mean you poached them or you interfered with your previous clinic's business. It happens all the time. And quite frankly, it's a commercial reality. And a lot of these clauses won't end up being enforceable anyway, because the amount is outrageous. 250,000 is outrageous, and it's not based in fact.
I think the key here, when you say that another staff member follows you, timing is probably a big factor. If you leave together, you're probably on the wrong side of the provision. But if you were to depart and then several months later or some months later, another person departs and lands at the same place where you are, it's more likely to be permitted.
Okay. There is one more question from Sagar.
On malpractice suits out of the scope of discussion for today. I don't know, Roman, are they out of the realm of discussion? We could talk about some if you like.
I would be, if there are no other questions, we can certainly entertain it, Romik, if you wish, or
if you have time,
time,
then for sure.
Okay. What's the question about the malpractice suit?
He's Sagar here, the gentleman with the nice display picture of the guitar. He's asking that in cases of lawsuits, this is a good general question, actually. In cases of lawsuits, is there any way for the defendant to recoup legal fees from the plaintiff if the ruling is in favor of the defendant? The answer is yes, of course. In cases where the defendant wins, i.e. the plaintiff loses, the plaintiff has not met their burden of proving their case, the defendant gets a figure of legal fees back, okay? And there's a scale that judges use and courts use to determine how much you should get in legal fees. And it goes, it's called partial indemnity, which is the minimum. And then it goes substantial, and then it goes full indemnity, which is 100%. So the scale percentage-wise, usually it's 60 to 65%, then 20 to 80%, and then 100% at the very top for full indemnity. Those numbers vary judge by judge, but generally speaking, in most cases, you're going to be looking at partial indemnity. And partial indemnity usually falls between, like I said, half of all your legal fees to 65% of all your legal fees. The reason that's the majority of cases is because that's the standard. And in order to meet the threshold to get more costs, you need to be able to show that the other side did something they shouldn't have done, right? That caused you to suffer more costs. So for example, the plaintiff's case was vexatious, right? Which basically is just a fancy word for saying it should have never been brought. There was never any case to begin with. It was in bad faith and so on. That could even get you full indemnity costs, right? If the cases should have never been brought and so on.
There are strategies in litigation which will allow you to maximize your cost award. So yes, a defendant can be awarded their costs or their expenses, and a good lawyer will advise you on how to maximize your recovery. Thank you very much for attending. We are both available to answer any of your questions. Feel free to reach out. Andreas has included our contact information. Either of us are both very good with electronic mail, and we would be very happy to pick up the phone and talk about an issue with you as well.
Thank you so much, Rahul. Thank you so much, Andre, for sharing this valuable information. And I will share your contact details in our WhatsApp group as well. And if you're okay, like some of the members, almost like 15 members, they have messaged me personally. They would like to see the recording of this. So if you're okay, I can share the recording with them as well. And yeah,
And I think you have the PowerPoint as well. So feel free to circulate that if you want to, if it's helpful.
perfect. Okay. So thank you so much. And with this, we're going to end the session and we'll see you for the next, maybe not you, we'll another speaker for other session. Okay. And thank you so much everyone for attending. And that was our first DAAC meeting. And there will be more sessions coming in. It's all about the mindset, the communication, networking, and the negotiation. That's it. This is the first step. Once we have the good associate contract, that's it.
It's very good that you're providing these resources for the business side of these relationships, which is often, that's the problem, right? That owners have been in the game a long time and they take advantage of younger folks who come in and they're eager to work, but their work doesn't, you don't learn how to read contracts in dental school, right?
That's true.
So it's important to have those, to flex those muscles and get those resources. So thank you very much for having us.
Yeah. Thank you so much. Yep. Goodbye.
Good evening. Take care.